Public Funds Public Schools for the 6th event in our 2020 webinar series. This webinar is Beyond Espinoza, Challenging Vouchers in the Courts. My name is Jessica Levin. I'm an attorney at Education Law Center and the director of Public Funds Public Schools, which is a collaboration of Education Law Center, the Southern Poverty Law Center, the SPLC Action Fund, and the law firm Munger, Tolles & Olson. PFPS is a national campaign dedicated to ensuring that public funds for education are used to maintain, support, and strengthen public schools. And you can visit our website, pfps.org, for more information and sign up for updates on our contact page. Today's webinar will be recorded and available later on the PFPS website. I want to remind everyone to please use the Q&A box, not the chat box, to submit your questions for our speakers. And I'm going to introduce our panelists now. I'll provide a very brief overview of our subject matter and pose some questions to the panel, and then we'll open up to audience questions. We have an incredible panel today to speak about the landscape of pro-public school litigation and advocacy in the wake of the Supreme Court's decision this summer in Espinoza versus Montana Department of Revenue. Kristen Haller is staff counsel at the National Education Association. NEA has been litigating against vouchers for years, and Kristen has a wealth of experience working on numerous voucher cases. We're very fortunate to have her share some of those experiences with us today. Dr. Preston Green is professor of educational leadership and law at the University of Connecticut and the John and Maria Neag Professor of Urban Education at the Neag School. He's published numerous articles and book chapters on legal and policy issues related to school privatization. And he's also featured in a previous PFPS webinar on the ways that voucher programs fail to provide civil rights and constitutional protections. That's on the PFPS website if you haven't caught it yet. Tamika Walker-Kelly is president of the North Carolina Association of Educators. She's also the lead plaintiff in a pending lawsuit challenging North Carolina's voucher program, one of the very first post-Espinoza voucher challenges. We're excited to hear more about that and the other efforts of public school advocates in North Carolina. And finally, Tamerlyn Godley is a partner at the law firm Munger, Tolles & Olson, which of course collaborates with Education Law Center and the Southern Poverty Law Center on the PFPS campaign. Tammy has served as lead counsel in several successful voucher cases, including the Lopez case that struck down Nevada's universal voucher law. And she recently led PFPS's successful litigation on behalf of the NAACP and public school families and districts to strike down a federal rule that would have illegally diverted hundreds of millions in federal emergency relief dollars away from public schools. The objective of this webinar is not to rehash the Espinoza decision, but rather, as the title implies, to go beyond Espinoza and explore the many avenues and strategies that remain open to those opposing vouchers in courts and elsewhere. However, I am going to give a very brief refresher about the case and a similarly brief overview of some of the current voucher lawsuits being litigated right now in the post-Espinoza environment. In 2015, the Montana State Legislature enacted a tax credit voucher program. The state would offer tax credits for donations to organizations that granted private school vouchers. Montana's constitution prohibits direct or indirect government aid to schools controlled by religious institutions. So the Montana Supreme Court concluded that the voucher program permitted the legislature to indirectly pay tuition at private religiously affiliated schools, violating the Constitution's no aid provision, and it struck down the voucher program. But the US Supreme Court in its June 2020 decision reversed. It held that applying the no aid provision discriminated against religious schools and families that wanted their children to attend those schools in violation of the First Amendment's free exercise of religion clause. This outcome was not wholly unexpected. It followed up on the US Supreme Court's controversial 2017 decision in a case called Trinity Lutheran. That case struck down Missouri's exclusion of religious institutions from a state grant program for playground resurfacing, holding that religious institutions can't be excluded from otherwise neutral government grant programs or benefits based solely on their religious character. And Espinoza purported to follow simply in that line of reasoning, as applied to the exclusion of religious schools from voucher programs based on their religious character or status. And many advocates fear that this line of cases, breaking down the separation between government and religion, will be extended further, as I'm sure our panelists will address. So finally, what are some of the current voucher cases that the Espinoza decision may or may not affect? And I'll leave it to our panelists to go into these in detail. But one of the most obvious examples is a set of cases in Maine, Vermont, and New Hampshire centered on the so-called town tuition programs in those states, which publicly fund private school tuition in the specific circumstances that a town doesn't have its own public school. Groups, including the pro-voucher law firm Institute for Justice, are challenging the exclusion of religious schools from these programs. The case in Maine was filed before the Supreme Court's Espinoza decision, and the others were filed afterward. But interestingly, the Federal Appeals Court in Maine just upheld the lower court's decision that religious schools can be excluded from Maine's tuition program without offending the First Amendment's guarantee of free exercise of religion. The Institute for Justice has said that it will petition the Supreme Court to take this case next, but the case hasn't been the slam dunk that voucher advocates may have envisioned. Another important pending voucher case is Bethel Ministries, in which a religious school sued state officials to challenge its removal from Maryland's voucher program because the school was found to violate the program's non-discrimination requirements. And there are other pending voucher cases that are further removed from the issues in Espinoza. For example, pending cases in Tennessee to challenge the ESA voucher law enacted there in 2019 are based on the law's targeting of two specific counties that have the voucher program, which violates the Tennessee Constitution's so-called home rule provision. So one of the messages that we hope you take from today's webinar is that despite the Espinoza decision, which was disappointing and deeply troubling to public school advocates, there are many paths left open to challenge vouchers in court. These include challenges under public education guarantees in state constitutions or under no aid clauses that prohibit government aid not just to religious schools, but to any private schools, as well as cases based on discriminatory policies in private schools that might participate in voucher programs. As I said, I'm going to leave the rest of the details to the panel. So without further ado, I'm going to pose to them our first question. So panelists, please give us your thoughts on what are the most important implications of the Espinoza decision on fighting private school voucher programs or otherwise. Tell us a little bit about what you think we should be looking out for in the short term and the long term. We're going to start with Kristen Haller.
Thanks, Jessica. Hi, everyone. So I think Espinoza is significant for two reasons. One is the most obvious reason, which is that it nullifies or at least weakens scores of state constitutional provisions that once served as an important tool for challenging voucher programs in court. No aid clauses like the one in Montana exist in about 3/4 of states, though not necessarily all of those provisions are impacted by Espinoza, as we'll probably discuss a bit later. And I think it's also significant that the court chose to do this at a time when vouchers pose an increasing threat to the promise of public education in this country. And I realize that's a bold claim, but I say that for two reasons. I think voucher programs have been growing. The bulk of enrollment is still confined to a handful of states, but it is growing. Early programs had relatively minimal impacts on state education budgets, but that's changing. Florida, for example, now has multiple voucher programs that may soon command upwards of 10% of that state's education budget. And this is at a time when, as I'm sure everybody knows, state education budgets are already under pressure. Many of them did not recover from the 2008 recession and have now been dealing with the impacts of COVID as well. And second, the nature of the schools participating in voucher programs has changed. In early voucher programs, there were some meaningful accountability requirements to ensure that participating schools provided an education of a certain minimal quality and that they were open to all students, even if that was so to a slightly lesser extent than public schools. One good example of an early program that had accountability requirements is the Florida Opportunity Scholarship Program, which was struck down in Bush versus Holmes in the early 2000s. And that program actually required participating schools to demonstrate fiscal soundness, accept students on a random and religion-neutral basis, and barred participating schools from charging additional tuition above the amount of the voucher. Among other requirements. And today what we're seeing increasingly is, private school choice really means that students are not free to choose schools so much as schools are free to choose students, with very few strings attached, apart from some household income caps that remain in place in most programs, although even those are changing. Newer programs subject participating schools in most cases to no meaningful oversight in terms of facilities, staff qualifications, or their curricula. And participating schools in almost all programs can and do discriminate against prospective students. This might include based on past academic performance, disability, sexual orientation, gender identity, and in almost all cases, religion. So that's the first very important, outcome of the decision. I think possibly the more important question raised by the case, though, is how far the Supreme Court is willing to go in using the free exercise clause as a sword to require states to fund private religious schools. Now, we've known since the early 2000s in Zellman versus Simmons-Harris that the Supreme Court was not willing to use the establishment clause to strike down voucher programs. But now the court is reading into the free exercise clause more of a requirement for states to fund religious schools. And this is really radical. It's a radical departure from our founders' motivations in enacting state and federal provisions concerning the separation of church and state. The Virginia Bill for Religious Liberty was in large part a reaction to programs that did provide funding for religious instruction. And with a sixth conservative justice on the court now, there's really no telling how far down this path the court wishes to go. Although we may get a preview soon, there's a case before the court currently called Fulton versus City of Philadelphia, which asks whether the City of Philadelphia could bar religious recipients of public funds from discriminating and offering publicly funded services in terms of foster care. So, it's really a radical decision, and I think it has tremendous implications going forward. So that's the glass half empty part of the presentation. I will pass the torch to whoever is next.
Thank you so much, Kristen. We will definitely get to the glass half full portion in the next question. You're right. Next, we'll go to Dr. Preston Green.
Yes, thank you so much for having me on this panel. And I'm going to start talking about glass half empty as well. But the Espinoza case is noteworthy because of the distinction made by the court between religious status and religious use. The court struck down the aid program because it discriminated against the religious status of the participants. In other words, the court found the restriction unconstitutional because it may have prevented the participation of religious institutions. However, the court left open the possibility of restrictions that prohibited the funding for religious use. An example of religious use would be religious instruction. Now, Justice Gorsuch, in a concurring opinion, rejected the majority's opinion's distinction between religious status and religious use. He stated that the free exercise clause protects religious conduct, not in addition to religious status. Therefore, he believed that the free exercise clause also protects against religious use restrictions. Now, this distinction, I think, is also probably on shaky ground with Justice Amy Coney Barrett's confirmation to the Supreme Court. Now, why is this important? Well, in addition to voucher programs, we also, I write a lot about charter schools. And one major implication of Espinoza's status use distinction is that it may have removed the barrier to religiously affiliated charter schools. A number of states prohibit charter schools from being affiliated religious institutions. Also, the federal government's charter school grant program prohibits participating charter schools from being affiliated with a sectarian school or religious institution. However, Espinoza's ruling prohibiting religious status restrictions for voucher programs may apply to charter schools. And indeed, Secretary of Education Betsy DeVos holds this view. And in last October, Secretary DeVos removed the restriction for federal charter school grants that prohibited charter schools from being affiliated with sectarian school or religious institution, citing the Espinoza case. So even if the Biden administration reverses this policy, it is likely that religious institutions will challenge this reversal as well as state statutes that prevent them from operating charter schools. Now, in the long term, I also should mention the concern about the possible removal of the religious use, religious status distinction. And in addition to the main case and other cases that we're going to be talking about going forward, I think that there's also a concern as well about charter schools. And the reason why I bring this up is that if the Supreme Court or the courts eventually removes this religious use, religious status distinction, not only could that argument apply to private school voucher programs, but it may apply to charter schools as well. Even though charter schools are defined as public schools, there are many legal scholars, including myself, who believe that charter schools have much in common with private schools. So there really is a lot to be concerned about as, as we look at these decisions going forward.
Thank you so much, Preston. Okay, we're going to go next to Tamika Walker-Kelly. And Tamika, I hope that you can spend a little bit of your time now to tell us some more about the North Carolina case that's going on right now.
Thank you, Jessica, and thank you to this organization for having me on this panel. Like Jessica said, my name is Tamika Walker-Kelly. I am an educator and I'm the president of the North Carolina Association of Educators. And I am one of the lead plaintiffs in our case of North Carolina. And just to give you a little overview of our particular case, our case claims that the voucher program here in North Carolina, also called Opportunity Scholarships, violates the state constitution. And it does that by funding schools that discriminate against families on the basis of religion, fund schools that discriminate against LGBTQ families and require students to adopt beliefs condemning LGBTQ rights. And then it fails to enforce any educational standards at schools funded with vouchers. So overall, in summation, we are not, through this lawsuit, not trying to bar the state from funding schools just because they are religious. We are trying to protect families from being victims of taxpayer-funded religious discrimination by voucher schools. And so that's a synopsis of the case that we are currently litigating. And like Jessica mentioned earlier, we are in active litigation, and I am an educator, I am not a lawyer. And so I will defer to the other legal minds on this particular call as our case and in the whole perspective of Espinoza. But I will note that one of the things that has been mentioned by the speaker from the NEA is that, we have to look at future causes in the long term of what kind of challenges will you bring about voucher programs to the courts, and making sure that those claims have viability, and claims that solely are based on state funds going to religious schools or religious activities will have to be considered as we move forward. So that is what I have.
Thank you very much. Okay, and to finish us off on this question, we have Tammy Godley from MTO.
Well, I would just say, as folks have stated, that the biggest result of Espinoza is that it's taken away one of the quivers and our arrows that we have in terms of not being able to use no-way clauses as to try and defeat voucher programs. But it's fair to say that we had long moved away from that already, or had been focusing on a lot of other things, which we'll talk about, I think, next. But that, the main thing now is just one less thing that we can look to and focus on and rely on in the fight. But the thing I think that is most concerning about it is what Dr. Green said as well, which is what happens, it's separate from no aid. We have a lot of ways to say, well, you can't discriminate. There's a bunch of other legal levers that we can potentially do relating to vouchers being used at religious schools. And with, Fulton v. Philadelphia, we'll see where that goes. Like, will that then, how far will this case, they had Trinity Lutheran, now there's Espinoza. How far will that be pushed? That will take away some of our other levers that I'm more concerned about. Honestly, just that where it stands right now, I'm not as concerned because we had moved away from that in any event. And our goal is not for no public funds to be used at any private school. So it's not about whether it's religious or not. The objection is actually across the board. So the no aid clauses were just another tool we had. But the real concern is how far will this be pushed to erode some of the other really important arguments we have against the use of public funds at private schools.
Thanks, Tammy. And I think that's a perfect segue to our glass half full portion of the questions that I have for the panel. And why don't we move backwards and start with you, Tammy? Can you tell us a little bit about some of the avenues and strategies that those of us who want to continue opposing vouchers post Espinoza in the court and or elsewhere, what are some of the strategies we can use, both proactive measures and reacting effectively to the Espinoza decision?
Yeah, well, I am definitely a glass half full person. So this is, easier for me to talk about. I tend to be like, no, it's not so bad. It's going to be fine. So I think we still have, honestly, most of the tools that we were relying on anyway. We are, and again, our goal is public funds to stay in public schools, regardless of, whatever type of private school. I mean, the first thing I think that's important to note is that the majority of people in America still oppose the use of public funds in private schools. That's a fact. And, we have, 85 to 90% of the kids go to public schools in the United States. So there is still a focus and the majority of folks in our country really want to see the public funds stay with public schools. I think we can focus on state constitutional mandates about providing, maintaining an adequate, in the constitutions have a variety of different languages that they use, but it is a mandate of every state constitution that they provide an adequate public education. And, I think Kristen's right. She alluded to this before that, as if voucher programs grow, then they start to erode the state's ability to provide adequate public schools. And that is a really important thing that we have our eye on. I think that we want to be looking at, the impact on, when we have a lot of states have vouchers right now for disability vouchers. And so we want to be looking at that. We want to look at what IDEA protections there are, what things, what we can be doing on that front. We want to be looking at discrimination issues, what legal principles we can use on the discrimination front if those are not further eroded. So I think, most of our tools are still there. And so in that way, I'm encouraged. And I think that Espinoza is kind of to the side at this point. And as I said, we're already moving away from such a reliance on no-wait clauses and relying on a lot of other important legal factors that we can continue to do and are completely unimpacted by Espinoza.
Thank you. Thanks very much, Tammy. Tamika, we're going to go back to you now. And if you wouldn't mind, since you are our resident non-lawyer on this panel, I know that everybody here also works with grassroots groups and non-legal advocacy groups, but I think you're one of the most up close with educators and parents and state and local groups in North Carolina. So could you also talk a little bit about the non-litigation efforts you've seen in the union and in other organizations and parent groups in North Carolina?
Sure. So I was just going to say there are two routes to looking at this. There is the legal way, which you can exercise through looking at, of course, your governing documents as a state, and then, of course, taking any sort of cases through the courts, which is what we're doing right now. But then there's also the grassroots method, and that part of that work is the public narrative around public schools and public school vouchers. One of the things that we know is that a lot of the general public, they are not aware of what the criteria, accountability standards, the different parts of what goes into these public school vouchers. And so we do a lot of political education of parents and educators and community members alike around what this really means for our public schools. And so we know that these voucher programs drain money that could be used better in our public school systems. And so when we talk about when the money leaves a public school, what happens to it? And so we have lots of conversations about that. And also in part of that narrative of political education to the general public, we also talk about and champion what's really good about public schools as well. Public schools have lots of measures, including accountability, that are not found in these private schools that take these vouchers. And so we talk about the wonderful school communities that are built in public schools. We talk about the strength and expertise and knowledge of our educators. And we talk about that parent-school connection that is naturally there for our public school environments that do not have to be mandated through contracts and community service hours that you find in lots of other private school and or charter and voucher environments. And so part of the work that we do as an organization is to champion what is great about our public schools, and also how those funds that are drawn from public school budgets, statewide budgets, can be used to continue to strengthen public schools.
Thank you very much. Preston, can you give us some of your glass half full recommendations and thoughts?
Will do. I think I actually, looking at some of the cases, have been, I find some reason to be positive. An example of this is actually, one example is the Bethel Ministries case, which Jessica mentioned. And just to give you a little background, in that case, the Maryland Department of Education removed the Bethel Christian Academy from the state's Boost program, which provides scholarships for low-income students who attend the state's private schools. And the Department of Education removed the school from the program because it was unconvinced that the school would comply with the program's prohibition against discrimination on the basis of sexual orientation. So this is like a religious use restriction. Bethel Christian Academy supports the biblical review of marriage defined as a covenant between one man and one woman, but the school claimed that it does not consider the sexual orientation on the basis of discrimination on the basis of sexual orientation. Now, the litigation thus far is that Bethel Ministries did seek a preliminary injunction claiming that its free exercise clause rights were violated. And what it argued was that it was being discriminated against because of religious status, that it was, it was because of its beliefs. But at the preliminary injunction stage, the court rejected that argument, saying that there was really no evidence that there was real discrimination based upon its status as a religious school. So this is an example of a case that might show some promise that this religious status restriction, religious use restriction may not be the barrier that we may think it is. Very briefly, Tamerlan discussed the issue of state constitutional mandates. I also believe that state constitutional mandates could be a way of challenging the expansion of voucher programs, especially as they relate to districts with high minority districts and districts that are struggling financially. And even though voucher programs have tended to be very small, as was noted, they are starting to expand. And I think that we can start making state constitutional arguments that specifically target these financially strapped districts that may be impacted, may not be able to provide a constitutional education as a result of this. And finally, I would say that there are federal statutes that can come into play and provide some support for, for public schools. An example of this would be Title VI. And Title VI is a federal statute that prohibits students from discrimination on the basis of national origin, and also the Equal Education Opportunity Act, which prohibits discrimination by an educational agency to overcome language barriers. Now, it's important to note that private schools do not receive federal funding, and therefore they're not usually required to provide language instruction to children who are not fluent in English. However, the state, is a recipient of federal funds and is therefore obligated to ensure that all its programs are accessible to children requiring English instruction. But there is a statutory provision in Title VI which states that the state may not directly or through contractual or other arrangements deny any individual any disposition, service, financial aid, or benefit. Now, the key about contractual or other arrangements suggests that this would also include private schools that are participating in voucher programs. So therefore, I think ELL students can make this argument for inclusion. And finally, I would mention Section 504. There was a US Department of Education letter to the Wisconsin Department of Public Instruction, which stated that the private or religious status of individual voucher schools does not absolve the state of Wisconsin of its obligation to assure that Wisconsin school choice programs do not discriminate against persons with disabilities. So there's also promise that even Section 504 could also apply to voucher programs. So I'm actually somewhat hopeful. I've woken up from my stupor after that decision.
Thank you very much. And Kristen, we'll go back to you for your thoughts on this question. And I'll just remind the audience again that if you have questions for our panelists, please put them in the Q&A box, and pretty soon we'll start picking some of those out and pose them to our panelists.
Thanks. I wholeheartedly agree with all those excellent thoughts. And just to add to that a little bit, challenges to voucher programs have actually never been based solely on no aid clauses. And in fact, in Florida litigation in the early 2000s that we participated in, known as Bush v. Holmes, we actually won a no aid clause before the Intermediate Court of Appeals there, challenge before the Intermediate Court of Appeals of Florida. And the Florida Supreme Court didn't really want to touch it, and instead decided the case based on the education clause instead. So I think it speaks a little bit to the power of prohibitions that are a bit broader than just religion, because religion is not really what the objection is to begin with. And prior cases have always had other challenges baked into them as well, local control provisions. Jessica, you mentioned the Tennessee case that's pending, but also there was another case in Colorado, Owens, that contained a local control challenge. Tax credit programs have been subject to tax uniformity challenges and legislative process challenges, single subject challenges, and more. And as Tammy indicated, all those challenges remain open. So it would be a mistake to overemphasize the impact of Espinoza on that front. And in addition, the sheer increase in certain voucher program sizes, that impact is uneven. We know it's uneven in certain school districts, and that may add weight to some of those challenges. And finally, there are a number of no aid to private schools clauses that don't just focus on religion and state constitution. So there are a number of avenues open to challenge. And then just to touch on something that Tamika said, I know we as lawyers often like to think that we, going to court is going to save the world and is going to move public policy, but non-legal challenges are perhaps more important in my mind. And school vouchers remain very unpopular. People don't want public money going to private schools. Our soon-to-be former education secretary has called public schools a dead end. And the public does not agree. Every time these programs are put up to referendum, they have lost by wide margins, generally about 2-1 in red states and blue states. Even in states with strong Republican majorities, we've seen that they can only pass with significant legislative mischief, as in Tennessee. So I think Americans still recognize that public schools are an important pillar of their communities and their democracies, and they don't want to see funds taken away from them and given to private schools.
Thank you for all those great ideas. I have questions for you, but I am going to use some of our great audience questions and pose a few of those. The first one we have is, what do you all think about the change of administration, the change of officials like the Solicitor General and the Secretary of Education? How do you see that influencing the momentum that pro-voucher groups may have gotten from Espinoza?
Well, in the most practical way, Betsy DeVos has spent 4 years trying to send as much money to private schools as possible, and in any way she could, and strategizing that. And so we won't be having to spend our time trying to protect against that. It's just on, we can focus on other things because the federal government will not be trying to do that. So I think that that's really, really helpful. And then, in turn, I mean, we're dealing right now in terms of after the equitable services, the boss put in the interim final rule that was going to siphon off a bunch of the CARES Act funds to private schools. That came on July 1st. By September 4th, we had it permanently vacated. But still, there's pressure on some states, and states are not doing the right thing in regard to this. And with the change of administration, we'll have the ability to make sure that the right rules are being followed. So we'll have both, more emphasis behind the right policies, and we won't have to be fighting against the bad policies. So we'll have more energy to be focusing at the state level.
Thank you, Tammy. Anyone else want to chime in on that question?
Yeah, I was just gonna echo what Tammy said. I think having a new Secretary of Education on the federal level who is actively supportive of public schools will be a huge help to states who are trying to make sure that we have adequate and substantial funding for public schools. It has been quite a while since we've had a Secretary of Education push vouchers so strongly. So I think having a new public education focused Secretary of Education is critical to changing some of the narrative that comes from the federal government.
I'll say something as well. I think that like on one specific change that you could see is that some of the federal provisions that I discussed, Section 504 and Title VI, where there may be mechanisms by which the federal government can have a say in how voucher programs are operated. You may see the Biden administration actually using those levers in ways that the previous administration has not.
Yeah, I agree. The tone at the top is going to be very important. I do think, just to sound a bit more of a cautionary note, that state houses haven't changed quite as much, and that I do think we will see in some states, legislation that seeks to take advantage of Espinoza. But again, there will remain other avenues to challenge that legislation if and when it is passed.
Thank you all. So talking then about the state level, and I would add that Public Funds Public Schools, I think, has our eye on both the federal and state level when it comes to pro-voucher policies and voucher cases. But we do work mostly at the state level because that is where voucher laws are passed and signed. Even though the vast majority of voucher bills that are proposed in state legislatures fail, that is where the ones that normally get through. We don't have a federal voucher program other than for Washington, D.C. So let me take one of our audience questions about the states. And this is a question about states that do have private school voucher programs, newly enacted, or where they've been enacted for a long time. And this audience member wants to know what is the potential role for statutory requirements that schools don't discriminate, or that they have a non-religious curriculum, or sort of safeguards or accountability measures through state statute.
I guess I'll start. I think as of now, I think the Espinoza case doesn't touch upon those. This goes to the religious use, religious status distinction that I discussed earlier, and some of these provisions are like I would view them as religious use restrictions, and so I don't think they're covered by Espinoza. And so I think that they can stand as of now. It's important to note that in the future, like with the Bethel Ministries case and some of these other cases that are percolating up, that the Supreme Court may have a chance to address that distinction. So that may go away in time.
Any other thoughts? I don't want to move on too quickly, but we have a lot of other questions. So thank you very much, Preston. That's very helpful. And let me ask another question about state constitutions and state law. You've all talked a little bit about state education clause guarantees in all state constitutions for a publicly funded public education, which, as Tammy said, vary in strength and specifically what they say. We've also heard a little bit about possible federal claims and causes of action about discrimination and other things under federal law. And you've briefly mentioned no aid clauses, but we have some questions about no aid clauses from our audience. So can some of you say a little bit more about what no aid clauses are and what you've alluded to, that some cover only religious schools, but some cover all private schools?
Yeah, so I can talk a bit about that. I mean, what we refer to as no aid clauses, it's actually a pretty heterogeneous group of state constitutional provisions. And so some of those have language in them that specifically prohibits aid to religious or sectarian schools. Some of them prohibit any kind of public funding to any school that's not under control of the state. And some of them, prohibit direct and indirect funding to private schools, as in Michigan. So, Espinoza pretty clearly applies to those provisions that single out prohibitions on sectarian schools receiving public funds. It's not clear how it applies to other provisions. So, for example, the South Carolina Supreme Court just was faced with a case where the governor had diverted a bunch of COVID aid to a private school voucher program, and the South Carolina Supreme Court, which has a religion neutral no aid clause, struck that down based on that provision. So.
Thank you. Yeah, and I'll mention Michigan's no aid clause, which is also a no aid clause that prohibits public funding of any private school, whether it's religious or not. And there is ongoing litigation that's now at the Michigan Supreme Court. It's a challenge to a law that would take money from the public education budget and reimburse private schools for a broad array of expenses. That is being challenged under that no aid provision. There has been some discussion of the Espinoza decision in that case recently in the Michigan Supreme Court, but it's also an example of something that is further removed from talking about funding of religious schools, because the point of that Michigan constitutional provision, which was enacted in the 70s by public referendum, the point is that no private school should be funded by the government, religious or not. So that's another case to watch. We have a question from one of our audience members directed to Ms. Walker-Kelly. This is asking, I think, about the messaging point that you were speaking about earlier. How do you see pushing back against the term school choice with its appeal to things like freedom? And our audience member says that this has been sort of the umbrella term for vouchers and all kinds of defunding measures. So can you talk a little bit about that?
Yes, so one of the things is that we know that school vouchers and school choice doesn't live with any party, actually. We categorize it as, we have public school educators and their supporters, and then privatizers, which cross party lines. So we, like you've mentioned, there are Democrats who embrace school choice and school vouchers as well. We have a couple here in North Carolina who do. So one of the things is that it's important to note that public schools offer plenty of choice, right? And so we have to make sure that we take back that particular language. We have all types of variations of public school education that are available to parents that many of them aren't aware about, from magnet school models to the traditional public school model. We have Montessori and all those different choices within the public school systems. And so we need to be able to communicate that much better to the general public as well, and also make sure that our legislators and our state governments are aware of the lots of different choices that they can fund through public dollars into our public schools.
Thank you. And does anybody else want to chime in on messaging and public communications? I'll mention that public funds, public schools, in addition to our litigation work, and Tammy has mentioned some of that, on our website, we have a number of resources that are intended to help public school advocates advocate for full and equitable funding of public schools and against the diversion of public funding to private schools. So on pfps.org, on our advocacy page, in addition to the recordings of webinars like this one, you'll also see things like policy reports and fact sheets to help make the arguments about the need for public school funding and for anti-discrimination for schools that follow all state and federal anti-discrimination measures, which private schools don't. We also have a research page that I want to mention because there's a lot of research thrown around in the debate over vouchers and other school privatization measures. And we have tried to compile the high quality, peer-reviewed, data-based research on all sorts of aspects of the effects of voucher programs, from the effects on student academic outcomes, to segregation effects, to civil rights effects, to their effects on the funding of public schools. So all that information is meant for the public. And if you see something that you would like PFPS to focus on, resources that you need in your state or community, then please get in touch with us. But I want to pivot for a moment away from litigation a little more and talk about legislation. We have a question from our audience about advice on pushing back against state level legislation that's seeking to create education saving account vouchers or other vouchers, because the Espinoza case, of course, came out of a Montana voucher legislation, creating a Montana tax credit program, and may have paved the way for us to see further legislation like that or other types of voucher programs. So I want to let our panelists talk a little bit about legislation at the state level.
I mean, one thing we need to make sure, I think most tax credit programs really fly under the radar. People aren't focusing on the fact that, this is money that would come to the public fisc, but isn't, since it's not. I mean, people get more kind of alarmed, there's $100 and we're going to pay some portion of that out to private schools. That's very clear to people. But the fact that we're not going to get the $100 in the first place because of these tax credit programs. So I think that there's a real need to do education around this and to get the public aware, because I think legislatures are passing this without people really having a sense of it. That being said, if you want to know how to do this, you should look to Arizona. The folks there have mounted, they mounted a grassroots initiative to block the expansion of their voucher program there. And they have been very successful in that. And just in this last term, they have, more folks that are supportive of public education that were elected to their state legislature. So, that is a good place to start. If you're looking for advice, there's some really fantastic people that are involved there. So look to that.
I also think that in addition, I also think about this issues of messaging as well in legislation, in that, look, we're coming out of just a major financial crisis, similar, even much worse than what happened a decade ago. And, if you're thinking about any type of programming or whatever, your first order of business is making sure that your constitutional duty of meeting your providing for public education is met. And in a period where you just don't have, where you're having a major financial strain, you really have to, when you're talking about these other programs, you have to be really discussing how public schools are being troubled right now with COVID and with all that's going on, and say, how are these other programs going to further compromise public education?
I would just build upon that too. We're also coming out of a time, or we're in a moment where there is a lot of focus on equity and discrimination and systemic bias. And we know that choice is largely people choosing away and taking money away that creates more inequities. And I think people are really resonating, and you just have to talk with people about it. I mean, when you talk with people and you say, you know, the most profound impact of quote choice is segregation. And people don't really focus on that and realizing the impact of that. And they don't like it when they hear about it and they don't want to be a part of it. That being said, you know, kids and where they go to school is very personal. But if you really have honest conversations with folks about this impact of all this is that we are continuing to segregate our schools in ways that we should not be proud of. People resonate with that, thinking about it.
Thank you. Any other thoughts about state legislation? If not, I'm going to ask the panelists now to each just take a minute or two to offer some final thoughts, your favorite voucher case that you've worked on or that someone else has worked on, or any final tips for our audience members. Why don't we start with Preston? Can we start with you?
Yes, I'll start. I think that, you know, I think that the major one in my research and what I've worked on, I think that one thing that I keep saying is that we really need to think not only just legislatively, but constitutionally that, you know, that our first order of business is to provide support for our public schools. So if we're doing anything else, the first question that we have to ask is, are we providing for public schools first? And if we're not, then we have to be very careful about other things that we're doing. There's been research in California, in Illinois, Chicago specifically, and also in Michigan, showing that how voucher programs, how school choice programs may have really negative impact, especially on districts that are predominantly Black and Latinx. So if we're not thinking, so we really have to be thinking about the impact that those programs may have on those communities' abilities to meet their duty to provide public education.
Thank you. Well said. Kristen, let's go to you next. Any final thoughts for our audience?
Yeah, I think I would just kind of reiterate a bit what I said earlier. You know, I think NEA has never objected to the right of parents to choose private schools. It's a question of, you know, what are our public funding priorities, and, you know, should public funds go to public schools that are open to all students, regardless of their religion, their disability, their past academic performance, gender identity, and you know, we believe that public funds should be going to public schools. So.
Thank you. We completely agree. Tammy, let's go to you next.
So I recently attended this terrific symposium put on by the Smithsonian Institute Natural History Museum on the power of funding in education. And I think there's all kinds of misinformation out there about how, you know, money doesn't matter, but that is entirely not supported by the research. Money spent well matters, and it is incredibly important in the world right now that we live in, where these increased inequities, that the one thing that we have to get right and have to do right for children is to give them a strong education, and we have to double and triple our commitment to that. And money matters. And so when we are siphoning off what is already not a public fist that isn't large enough, and which with the pandemic is even more, as Dr. Green said, even more impacted, we have got to get this right. We've got to be keeping our funds with schools. We've got to be spending it wisely. We have to be protecting it. And we know that there are groups of folks that are around the country that are focused on privatizing education. That is their goal. And we just have to be so vigilant about making sure that we're protecting that money, because money matters in schools. And the more money that you have to spend, the better you can provide education for students. And that's why, private schools that cost like $40,000 around, I live in Los Angeles, but they cost lots of money. And that's because it takes a lot of money to provide an outstanding education. And we need to be committed to that for our public schools.
Thank you very much, Tammy, and for your work toward that too. And Tamika, will give you the last word for some final thoughts, and then we'll wrap up.
So I will just kind of echo what Preston said. It's really important for people to be knowledgeable about what is in their state governing documents. Here in North Carolina, it is constitutionally mandated that every student be provided a sound basic education. And what private school vouchers do is it creates two systems which it leaves the public school system underfunded. And the state must make sure that every student here in North Carolina has a high quality public education. And so we strongly believe here at NCAE that public dollars belong in public schools, and that we can have a robust public education system when we make sure that we include transparency for our public tax dollars and also accountability for them as well.
Thank you very much. Well, I think that today has made clear that there is much work to be done, but our panelists have given us great ideas and a great deal of optimism that working together with families, communities, advocates and attorneys across the country, we have many avenues to continue the important work of keeping public funds where they belong, in public schools. So I want to thank all of our outstanding panelists. And I also want to let you know that our final webinar of the year will be December 16th at 3 Eastern. It's going to feature Jennifer Berkshire and Jack Schneider to discuss their new book, Wolf at the Schoolhouse Door. So please remember to visit the PFPS website, pfps.org, sign up on the contacts page to receive registration info for webinars and other updates on our work. And our webinar, of course, is where you can access some of the resources that were discussed today. We look forward to seeing you all again, and thank you again to our panelists.